Chapter 3. Norway, the imported king, engaged by contract. The Norwegian monarchy is the youngest in Europe. It has not yet attained 120 years of age. The Norwegian crown was fabricated quite literally yesterday, before the eyes of generations still living, by a procedure that more nearly resembles the hiring of a chief executive by a corporation than the restoration of an ancient throne. In the year 1905, Norway dissolved her union with Sweden. From 1380 onward, she had lain under alien crowns, first the Danish, until 1814, thereafter the Swedish. Norway had possessed no native dynasty for more than 500 years. The last Norwegian king to govern from Oslo was Håkon VI, who died in 1380. And when the question arose as to who should occupy the vacant throne, the Norwegian Storting comported itself like a body of shareholders electing the chairman of a board. It published a notice of the vacancy, scrutinized the candidates, and engaged a Danish prince. It examined several candidacies. It conducted an interview. It required the candidate to submit himself to the approval of the collective, the Norwegian people, by way of a referendum. And only then did it sign the contract. This is no monarchy. It is an elective office bearing a hereditary vesture. The King of Norway is no Lord's anointed, no heir of an immemorial dynasty, no living embodiment of the nation's history. He is an imported Danish prince, engaged by the Norwegian parliament to perform a labor whose conditions were set down in the constitution, in a referendum, and in political arrangements. And the whole subsequent history of the Norwegian crown is a tale of the progressive dissolution of even such wretched remnants of legitimacy as it might have possessed. 3.1. The Constitution of 1814, a forced Swedish union. Before we can speak of how Norway obtained her king in 1905, we must first understand how she lost him. And here we collide with a document that the Norwegians venerate as the cornerstone of their statehood, the Constitution of Eidsvoll of 1814. Yet once the patriotic varnish is stripped from this document, an unsightly truth stands revealed. The Norwegian constitution was composed in haste, beneath the muzzles of Swedish cannon, and was imposed upon the country by the great powers who were partitioning Europe in the aftermath of the Napoleonic Wars. The Napoleonic Wars redrew the map of the continent. Denmark, the ally of Napoleon, suffered defeat. By the Treaty of Kiel of 1814, the Danish King Frederick VI ceded Norway to the Swedish King Karl XIII. It was a classic transaction of the great powers. Territories passed from hand to hand like counters in a game of cards, and the peoples who inhabited them were consulted by no one. The Norwegians endeavored to resist. In May of 1814, the Constituent Assembly at Eidsvoll proclaimed Norway an independent kingdom, adopted a liberal constitution, and elected as king the Danish Prince Christian Frederick. Yet this act of free will endured precisely as long as the Swedish army required to march upon the Norwegian capital. In July of 1814, Sweden invaded Norway. The war was brief, and its outcome foreordained. Norway capitulated. The Convention of Moss, signed in August 1814, embodied the compromise. Norway acknowledged the Swedish king as her sovereign, yet retained the Constitution of Eidsvoll, with amendments accommodating the union. On the 4th of November, 1814, the Storting formally elected Karl XIII as King of Norway. The Swedish-Norwegian Union entered into force. Mark well that word, elected. From her very inception, the Norwegian monarchy was not hereditary but elective. The Storting voted for its king. And although this procedure was subsequently forgotten, and the throne passed by inheritance within the House of Bernadotte, the bare fact that the Norwegian crown was instituted by a parliamentary vote, tendered under military duress, has forever stripped it of any sacral character. For 91 years, Norway lay in personal union with Sweden. She possessed no king of her own, no foreign policy of her own, no diplomatic corps of her own. The Swedish king governed Norway from Stockholm. The Norwegians were the subjects of a foreign sovereign. And when, in 1905, the union was at last dissolved, Norway found herself confronted with the question, what was to be done with the empty throne? 3.2. Håkon VII, the imported Dane. In the summer of 1905, the Storting adopted a resolution dissolving the union with Sweden. The Swedish king, Oscar II, renounced his rights to the Norwegian throne. Norway became an independent state. Yet under what form, republic or monarchy? The Norwegian government, headed by Christian Michelsen, inclined toward monarchy. The reasons were pragmatic, not ideological. Monarchy lent the young state legitimacy in the eyes of the European powers. A republic in Norway would have looked suspect, too closely resembling French radicalism. Moreover, the Norwegian elite feared that a republic would lead to political instability and, quite possibly, to a fresh union with Sweden upon terms less advantageous still. But whom to place upon the throne? Norway had possessed no native dynasty for 500 years. The last Norwegian king to govern from Oslo was Håkon VI, who died in 1380. From that day forward, Norway had been a province, first Danish, then Swedish. The Storting commenced its search for a candidate. Sundry variants were debated in the corridors. For a time, the candidacy of a Swedish prince was entertained in earnest, the very same from whom Norway had just torn herself free. This notion was rejected as a political suicide. Thereafter, eyes turned toward Denmark. The Danish royal house of Glucksburg enjoyed the reputation of being liberal and democratic, insofar as one may speak of liberalism in connection with a monarchy. The Danish crown Prince Frederick had a younger brother, Prince Karl. He was 33 years of age. He was married to Maud of Wales, daughter of the British King Edward VII. He already had a son, 2-year-old Alexander, which guaranteed a succession. The Norwegian delegation set off for Copenhagen. Prince Karl heard the proposal, and he advanced a condition that forever fixed the character of the Norwegian monarchy. He would consent to become king only in the event that the Norwegian people, by referendum, pronounced in favor of monarchy. From his own standpoint, it was a brilliant piece of statecraft. From the standpoint of dynastic law, it was a catastrophe. Prince Karl of Denmark did not declare, "I possess a right to this throne by blood, by descent, by the operation of dynastic statutes." He declared, "I shall accept this throne if the electors choose to engage me." He himself, of his own free will, placed his legitimacy and dependence upon a popular ballot. He acknowledged that his right to the crown was not inborn, but acquired. Not divine, but democratic. On the 12th and 13th of November, 1905, the referendum was held in Norway. 259,563 persons voted for monarchy, 69,264 for a republic. With a turnout of approximately 75%, this signified that roughly 79% of those who voted preferred the crown. On the 18th of November, the Storting formally offered Prince Karl the throne. That same evening, he accepted the offer, taking the ancient Norwegian name Håkon VII. On the 25th of November, the new king and his family arrived in Christiania, the present Oslo. On the 27th of November, he swore his oath before the Storting. Behold the juridical construction of the Norwegian monarchy, stripped to the bone. No hereditary right, no blood, no tradition, a referendum, a parliamentary ballot, an oath sworn before the representatives of the people. Håkon VII became king, not because he was born to it, but because he was chosen. The principle of indigenat demands that a monarch be a native of his own country. He must have been born upon its soil. He must speak its tongue as his mother's speech. He must be flesh of the flesh of that land. Håkon VII satisfied not a single one of these requirements. He was born at Charlottenlund, near Copenhagen. He was a Danish prince, the son of a Danish king, reared in Danish traditions. His native tongue was Danish. He had never dwelt in Norway before he became its king. He was a foreigner, a pure, unvarnished foreigner, hired to labor in an alien country. His son, Olav V, was born in England. His mother, Princess Maud, preferred to be delivered upon her native soil. The Norwegian constitution, needless to say, contains no requirement of birth upon the territory. It suffices to be the lawful descendant of the monarch. Yet we have already established, within the pages of this book, a principle that admits of no contradiction. A constitution cannot render a monarch legitimate. From the standpoint of classical dynastic law, indigenat demands that a ruler be born of the very earth he governs. Olav V, who drew his first breath in an English hospital, is as much a foreigner by blood and by place of birth as his father was. Parliamentary fictions do not repeal dynastic law. Olav V is thus equally unlawful upon the Norwegian throne. His grandson, Harald V, became the first Norwegian king in upwards of 500 years to be born upon Norwegian soil. Yet his blood remained Danish. The Glucksburgs are a Germano-Danish line that has struck no roots whatever into Norwegian earth. From the standpoint of classical dynastic law, this suffices for a finding of absolute illegitimacy. A monarch cannot be imported. A monarch must grow forth from the land he governs. The Norwegian monarchy is no Norwegian institution. It is a Danish branch office, opened at Oslo in the year 1905. 3.4. Queen Sonja, a morganatic marriage and the blackmailing of the throne. If the foundation of the Norwegian monarchy was illegitimate, its subsequent history has only compounded that illegitimacy. And the most vivid instance of this is the marriage of the present king, Harald V, to Queen Sonja. Sonja Haraldsson was born in 1937, the daughter of a clothing merchant. She was a commoner, no aristocrat, no princess, no person of royal blood. She studied dress design, sewed, traveled, and lived an ordinary life. In 1959, at a dance, she made the acquaintance of Crown Prince Harald. They fell in love. From the standpoint of classical dynastic law, this romance was foredoomed. A crown prince could not marry a commoner. Such a union would be accounted morganatic, and the issue of it would possess no right to the throne. King Olav V, Harald's father, understood this perfectly. He forbade his son even to contemplate marriage with Sonja. For 9 years, the couple met in secret. For 9 years, the heir to the Norwegian throne led a double life. And at the last, he presented his father with an ultimatum. Either he would marry Sonja, or he would renounce the throne. Given that Harald was the sole heir, his elder sister, Princess Ragnhild, had married a commoner and forfeited her rights to the throne, and the second sister, Princess Astrid, had likewise contracted an unequal marriage. Harald's renunciation would have signified a dynastic crisis. King Olav consulted the government, the presidium of the Storting, and the leaders of the political parties. The answer he received was, the country does not object. In 1968, Harald and Sonja were wed. From the standpoint of dynastic law, this union is a morganatic marriage in its purest form. Sonja Haraldsson was no person of royal blood. She was the daughter of a shopkeeper. Her children, Princess Martha Louise and Crown Prince Haakon, were born of a morganatic union. Consequently, they possessed no right to the throne. Yet the Norwegian monarchy, which lacks any formal concept of a morganatic marriage, simply disregarded this. Parliament approved the union. The king gave his consent. All concerned affected to see no difficulty. And today, the heir to the Norwegian throne is Haakon, the son of a commoner, a man whose mother sewed dresses to order rather than wearing a crown. Moreover, the very manner in which Harald extracted the consent to his marriage annihilates any pretensions the Norwegian monarchy might have to a sacred character. The heir to the throne blackmailed his father with the threat of abdication. He was prepared to cast away the crown for the sake of a woman. This is the conduct, not of a monarch, but of a lovesick youth. And the fact that the king and the government yielded to this blackmail merely confirms the truth. The Norwegian crown possesses not the slightest worth. It may be accepted or tossed aside upon a private caprice. It is no sacred duty. It is an accessory. 3.5. Princess Martha Louise, shamans, angels, and commercial gin. If the marriage of Harald and Sonja undermined the dynastic foundations of the Norwegian monarchy, the activities of their daughter, Princess Martha Louise, have annihilated its moral authority. Martha Louise is the king's elder daughter. Under the Norwegian laws of that period, she could not inherit the throne, for she had a younger brother. Yet she bore the title of princess and received a maintenance from the state. In 2002, she married the author Ari Behn. In 2019, they were divorced. In 2023, she became engaged to the American Durek Verrett. Who is Durek Verrett? He is no mere man of the people. He is an African-American who will go down in history as the first black man to ally himself by marriage with a European royal house in the modern era, and this in a country where, a bare half-century ago, the very thought of such a union would have provoked a constitutional crisis. He is a bisexual who has had a long-standing relationship with a man and was previously bound in a heterosexual marriage. He is a convicted felon, having served a prison term for arson and faced charges of domestic violence. He is a self-proclaimed sixth-generation shaman who sells amulets purporting to heal cancer and COVID-19, claims to have risen from the dead, and asserts in all seriousness that chemotherapy is a swindle. And this man is no mere guest at a royal reception. He is the husband of Princess Martha Louise, the elder daughter of King Harald V, fourth in the line of succession to the Norwegian throne. A princess who herself styles herself a clairvoyant, converses with angels, and once directed a school of angels, where she taught Norwegians to commune with the spirit world. This match is no mere mésalliance. It is a ritual suicide of the monarchy, a demonstrative gob of spittle flung into the face of all who yet believe that a royal family is a model of virtue and traditional values. And whilst the Norwegian taxpayers foot the bill for this pair, Verret and Martha Louise are bringing out a limited edition gin bearing their monogram, in breach of every conceivable law governing the advertisement of alcohol and royal protocol. This is no longer decay. This is an open capitulation to absurdity. In 2022, Martha Louise renounced her official royal duties. The reason was that she had employed her title for commercial ends, to promote a business connected with alternative spirituality. King Harold took a decision. She retains the title of princess, yet she binds herself not to employ it in any commercial undertaking. In the summer of 2024, a fresh scandal erupted. For her wedding to Verret, Martha Louise issued a limited edition gin. Upon the label was emblazoned her monogram and the legend. The gin was created for the wedding of Princess Martha Louise and Durek Verret. The Norwegian Directorate of Health launched an investigation. The advertisement of alcohol is forbidden in Norway, and the use of a royal title to promote spirituous liquor constitutes a violation of the grossest kind. The princess's spokesman termed the affair an error. Martha Louise herself preserved a silence. Yet the essence of what occurred is clear. A member of the Norwegian royal family, while retaining the title of princess, is trafficking in spirits, sheltering herself behind her royal status. This is no mere breach of the law. It is a gob of spittle in the face of the Norwegian people, who pay for the upkeep of the royal family. From the standpoint of classical monarchy, the conduct of Martha Louise is a death sentence upon the institution. A princess cannot trade in gin. A princess cannot marry a charlatan shaman. A princess cannot treat people's cancers with amulets. All of this undercuts the very idea of monarchy as an institution that stands above commerce, above superstition, above the commonplace. 3.6. Crown Princess Mette Marit, a waitress with a narcotic past on the path to the throne. If the marriage of King Harold to Sonja Haraldsson constituted a violation of dynastic law, the marriage of his son, Crown Prince Haakon, to Mette Marit Jessam Højby is a direct outrage upon the very notion of royal dignity. This is no mere morganatic union. It is the deliberate choice of an heir to the throne to bind his life to a woman whose past would have excluded her from the faintest possibility of approaching a court in any preceding epoch of European history. Mette Marit was born in 1973 at Kristiansand, the daughter of a journalist and a bank clerk. After her parents' divorce, she dwelt with her mother, was a mediocre scholar, and worked as a waitress. In the mid-1990s, she formed part of a coterie that revolved about the nightclubs of Oslo and was notorious for the consumption of narcotics. In 1997, she bore a son, Marius, to a drug dealer subsequently convicted for possession of cocaine. Mette Marit herself was never criminally prosecuted, yet her presence at parties at which heavy narcotics were consumed was documented and widely reported in the Norwegian press. In 1999, at a music festival in Kristiansand, she made the acquaintance of Crown Prince Haakon. A romance commenced. When it became public knowledge, Norwegian society detonated. The newspapers blazed with headlines of a Cinderella with a dark past. Politicians demanded explanations. The royal court preserved a silence. In the year 2000, Haakon and Mette Marit began to cohabit. In December of 2000, their betrothal was announced. And then there erupted a scandal the like of which the Norwegian monarchy had not known since the day of its founding. The Norwegian press published the particulars of Mette Marit's past, the narcotic parties, the ties to criminal elements, the child born out of wedlock. The approval rating of the monarchy plummeted to an historic nadir. On the 25th of August, 2001, a few days prior to the wedding, Mette Marit appeared at a press conference to deliver a statement that was meant to be an act of contrition, yet proved in fact to be an act of public degradation of the Norwegian crown. With tears in her eyes, she declared, "I wish to take this opportunity to say that I condemn drugs. I know that I was at parties where drugs were consumed. I was young, and today I look back with shame. I wish to apologize to the Norwegian people." From the standpoint of classical dynastic law, this marriage is not merely morganatic. It is disgraceful. In former epochs, a woman with such a past could not even have drawn near to a court, let alone become the wife of the heir to the throne. Her son by a prior liaison is a living memorial of her pre-royal existence, a bastard reared within a royal palace. Yet the Norwegian monarchy, created in 1905 as an elective office, possesses no mechanism to defend itself against such unions. Parliament may approve any match. The king may grant his consent to any marriage. Public opinion may forgive anything at all. And the result? In 20 years' time, Mette-Marit will have become Queen of Norway. A woman who once frequented narcotic dens will sit upon the throne of the ancient Viking Konungur. This is the final verdict upon the Norwegian monarchy. An institution that cannot defend itself against the penetration of persons with a criminal past into its very core has no right to exist. A monarchy that depends upon the indulgence of parliament and the tolerance of public opinion is no monarchy. It is a costly theater in which the actors change while the scenery remains. 3.7. The Epstein Connection, the future queen and the sex trafficker. If Mette-Marit's past, a waitress, a single mother, a participant in narcotic parties, could be written off as the errors of youth, her long-standing connection to Jeffrey Epstein admits of no statute of limitations. This is no youthful folly. It is the deliberate choice of a grown woman, the crown princess of Norway, the future queen, to maintain close relations with a man who was convicted of sexual crimes against minors. In February of 2026, the United States Department of Justice released a fresh tranche of documents in the Epstein case, more than 3.5 million files. The name of Mette-Marit appears in these materials more than 1,000 times. This is no incidental mention. It is a correspondence of many years' duration, meetings, visits to Epstein's residence in Palm Beach, private conversations difficult to construe as anything other than evidence of an intimate friendship. In January of 2013, Mette-Marit spent 4 days at Epstein's residence in Palm Beach, Florida. The royal court confirmed the visit, clarifying that she was there with a female companion, and that Epstein was absent at the time. The published files demonstrate, however, that a meeting with Epstein did take place. The palace lied. The future Queen of Norway not only dwelt in the house of a convicted pedophile, she personally met with him upon those premises. This is no mere poor judgment. It is a conscious concealment of the truth. The royal court preserved a silence. The press office declined all comment. Rain was falling, and no one wished to venture out without an umbrella. And then the storm broke. The publication of the Epstein files, the trial of Marius, the revelations concerning the correspondence. And there were not enough umbrellas to go round. A chronology of shame. Epstein was convicted in 2008 of soliciting a minor for prostitution. He served 13 months in the Palm Beach County Jail and was thereafter released as a registered sex offender. Any public person who valued his reputation would, after such a conviction, have severed all contact with Epstein. Any person, but not Mette-Marit. The correspondence between the crown princess and Epstein, according to the published files, was conducted from 2011 to 2014, 3 years after he had become a registered sex offender. What, precisely, the future Queen of Norway wrote to a convicted pedophile. The files released by the United States Department of Justice contain not merely mentions of Mette-Marit's name. There are more than 1,000 of them. This is no chance correspondence. It is a dialogue of many years standing, intimate, charged with emotion, difficult to interpret as anything other than evidence of a close friendship. Here is what the Crown Princess of Norway wrote to a man whose name had become synonymous with the sexual exploitation of minors. Quotation from Mette-Marit's correspondence context. Paris is good for adultery. Scandy's better wife material. Epstein had informed her that he was in Paris hunting for a wife. The future queen's reply is not indignation, not a drawing back, but a playful wink. Calls Epstein sweetheart, soft-hearted, very charming. These epithets are scattered throughout the correspondence. In the eyes of the crown princess, a convicted pedophile is a soft-hearted sweetheart. You always make me smile. Because you tickle my brain, this is no social pleasantry. It is flirtation. A woman who will become queen in a few years' time writes to a sex trafficker that he tickles her brain. I googled you. It didn't look too good, smiley face, the year 2011. 3 years after Epstein had pleaded guilty to the solicitation of a minor. She knew. She saw. And she added a smiley face. Would it be inappropriate for a mother to suggest 2 naked women carrying a surfboard as wallpaper for my 15-year-old's room? She puts this question to Jeffrey Epstein, to the man whose speciality is the sexual exploitation of adolescents. And she awaits his counsel on the rearing of her son, the selfsame son who, 14 years later, will sit in the dock, charged with serial rape. Read these lines again, slowly, deliberately. Imagine that they were written, not by some abstract crown princess, but by your own neighbor. A woman who calls a convicted pedophile sweetheart and soft-hearted. A woman who jests about adultery with a sex trafficker. A woman who, upon learning of his crimes, inserts a smiley face and continues the correspondence. A woman who asks him for advice on what sort of wallpaper depicting naked women to hang in the room of her 15-year-old son. Now imagine that this woman is the future queen of Norway, that she shall sit upon the throne, receive the oath of the government, represent the country at international summits, and deliver orations upon values and morality. That her portrait shall hang in public buildings, that she shall be styled Her Majesty. This is no mere moral lapse. This is a total, irreversible forfeiture of the right to the crown. In classical dynastic law, a monarch must be a model of rectitude. His reputation must be spotless. A woman who, for years, flirted with a convicted pedophile, dwelt in his house, and sought his counsel upon the rearing of her son cannot be a queen. She possesses no moral right to this. The fact that the Norwegian royal court, after the publication of these letters, confined itself to a perfunctory statement about poor judgment, merely confirms the truth. The institution is rotted through. A monarchy that cannot defend itself against the entry of persons with such moral deafness into its very core has no right to exist. What is more, in 2011, Mette Marit herself wrote to Epstein, "Googled you after last email. Agree didn't look too good, smiley face. I Googled you after your last email. I agree, it didn't look too good, smiley face." She knew. She saw the information concerning his crimes. And she carried on the correspondence regardless. The smiley face at the close of this message is not merely a piece of inept punctuation. It is the token of a complete moral stupefaction. The substance of the correspondence: "You tickle my brain." The published letters paint a portrait of a relation that stretches far beyond the bounds of formal acquaintance. Mette Marit styled Epstein very charming, soft-hearted, such a sweetheart. In one missive she wrote, "You tickle my brain." When Epstein sent her flowers, she replied, "You are such a sweetheart." In 2012, Epstein informed her that he was in Paris on a wife hunt. Mette Marit's reply: "Paris is good for adultery. Scandy's better wife material." This is no social discourse. It is, at the very least, flirtation with a convicted pedophile, if not something graver still. When Epstein sent her flowers, she answered, "You are such a sweetheart." When he proposed a meeting, she wrote, "Are you coming to see me soon? I miss my crazy friend." In January of 2013, Mette Marit spent 4 days at Epstein's residence in Palm Beach, Florida. The royal court confirmed the visit, specifying that she was there with a female companion and that Epstein was absent at the time. Yet the bare fact remains. The future queen of Norway dwelt in the house of a convicted sex offender. She made use of his property. She accepted his hospitality. This is no mere error of judgment, as she subsequently styled it. It is the conscious exploitation of the resources of a man who amassed his fortune by trafficking in children. The counsel of the naked women for a 15-year-old son. The most shocking episode of the correspondence touches Marius Borg-Høiby, the selfsame son of Mette Marit, who now stands trial for serial rape. In November 2012, when Marius was 15 years of age, Mette Marit wrote to Epstein, "Would it be inappropriate for a mother to suggest 2 naked women carrying a surfboard as wallpaper for my 15-year-old's room?" Epstein replied, "Let them decide for themselves. A mother ought not to interfere." Let us pause and read that again. The future queen of Norway asks a convicted pedophile whether it is fitting to decorate the room of a 15-year-old adolescent with wallpaper depicting naked women. She does not ask her husband, Crown Prince Haakon. She does not ask pedagogues. She does not ask psychologists. She asks Jeffrey Epstein, a man whose peculiar province is the sexual exploitation of minors. This is no mere poor judgment. It is a monstrous, unforgivable absence of the maternal instinct and of all moral bearings. A woman who puts such a question to a pedophile has no right to rear children, still less to be a queen. The attempt to cover the tracks and the public humiliation. It is telling that the Prime Minister of Norway, Jonas Gahr Støre, publicly endorsed this assessment, declaring that he agreed. The Crown Princess had indeed displayed poor judgment. The head of the government of a sovereign state finds himself obliged to comment upon the quality of the future queen's choice of friends. This is not merely humiliating for the monarchy. It is a demonstration that the royal family in Norway is no sacral institution, but an object of political oversight. The Prime Minister sits in judgment upon the conduct of the Crown Princess, as a schoolmaster sits in judgment upon the conduct of a wayward pupil. Falsehoods, the covering of tracks, the manipulation of public opinion, and when the falsehoods were laid bare, a perfunctory apology and the plea to move forward. This is not the bearing of a monarch. It is the bearing of a politician caught in an act of corruption. Crown Prince Haakon, complicity in silence. Particular attention must be paid to the role of Crown Prince Haakon. In March of 2026, after the publication of the files, he gave an interview to the Norwegian Broadcasting Corporation, NRK, in which he acknowledged he knew of his wife's friendship with Epstein. He knew of their meetings in the United States. He knew that when Epstein came to Oslo, Mette-Marit walked with him through the Frogner Park. The future king of Norway knew that his wife was the intimate friend of a convicted pedophile, and he did nothing. He did not intervene. He did not warn. He did not put a stop to it. He suffered the thing to continue for years. This is no mere passivity. It is complicity. A monarch who cannot defend the honor of his family and of his crown against such associations has no right to wear the crown. The context, the connection to the Marius affair. One cannot but remark the diabolical synchronicity. The publication of the Epstein files occurred at the very moment when Mette-Marit's son, Marius Borg-Høiby, was preparing to stand trial upon charges of raping 4 women. The mother of an accused serial rapist was for years the intimate friend of the most notorious sex trafficker of the age. She sought his counsel upon the rearing of her son, the selfsame son who now sits in the dock. Coincidence? Perhaps. Yet in dynastic law, as in criminal law, coincidences of such magnitude do not occur. A pattern is discernible. The environment fashions the man. A mother who flirts with a pedophile and discusses with him wallpaper bearing naked women for the room of her teenage son could not rear a son of sound moral character. And the result we behold in the courtroom of Oslo. The juridical and moral dimension. From the standpoint of classical dynastic law, the intimate connection of a member of the royal family with a convicted sex offender is no mere scandal. It is a forfeiture of the right to the throne. A monarch must be a model of rectitude. Their reputation must be spotless. A woman who, for years, corresponded with Epstein in a playful tone, dwelt in his house, accepted his gifts, and sought his counsel upon the rearing of her son cannot be a queen. She possesses no moral right to wear the crown. The fact that the Norwegian royal court endeavors to muffle this scandal with perfunctory apologies merely confirms the total degradation of the institution. 3.8. Marius Borg-Høiby, a rapist bastard beneath the palace roof. If the marriage of Crown Prince Haakon to Mette-Marit constituted a violation of dynastic law, the presence within the royal family of her son by a prior liaison, Marius Borg-Høiby, is no mere violation. It is a demonstrative outrage upon the very notion of royal dignity. Marius was born on the 13th of January, 1997, the fruit of a brief romance of Mette-Marit with Morten Borg, a man later convicted for the possession of narcotics and for assault. When Mette-Marit wed Crown Prince Haakon in 2001, the 4-year-old Marius moved with his mother into the royal residence of Skogum. He was given no title. He was not placed in the line of succession. Yet he was lodged in a palace, reared as a member of the family, and Crown Prince Haakon publicly styled him my son. And what has grown forth from this experiment in mingling royal blood with a criminal past? A serial rapist. Neither Crown Princess Mette-Marit nor Crown Prince Haakon attended the first sitting of the trial. They preferred, at that moment, to be upon an official journey abroad. Now let us pose the question that must interest every legitimist. Does Marius truly possess no rights to the throne? The official version declares, no, he does not. He was not adopted by Crown Prince Haakon. He bears no title. He is not included in the line of succession. From the standpoint of the Norwegian constitution, the matter is settled. Yet in dynastic law, there is no such thing as a member of the family without rights. You are either a member of the dynasty, or you are an outsider. Marius Borg-Høiby dwells within a royal residence. His mother is the future queen of Norway. His stepfather is the future king. His half-siblings are heirs to the throne. He appears upon family photographs, takes part in private engagements, and his name figures in the context of the royal family. The palace, endeavoring to distance itself from the scandal, asserts that Marius is not a member of the royal family and not a public figure. Yet this is juridical casuistry. If he is not a member of the family, why does he dwell in a palace? If he is not a public figure, why did his arrest unleash the greatest scandal in the history of the Norwegian royal family? What is more, the bare fact of Marius's existence creates a dynastic time bomb. Imagine a hypothetical scenario. Something befalls Crown Prince Haakon and his lawful children. The Norwegian throne falls vacant. Who is next in the line of succession? Distant kinsman from the Danish branch of the Glucksbergs? Or, perchance, will the Storting decide that the elder son of the crown princess, albeit born before the marriage, possesses a stronger moral claim than an imported Dane? In dynastic law, where blood signifies everything, the presence of a bastard of doubtful status is a mine that may at any moment explode. And now let us contemplate Marius from the standpoint of tattoos. The Norwegian and international media describe his appearance as that of a tall, blonde man cultivating the image of a bad boy. Hair slicked back, earrings, rings, and tattoos. This is no minor detail. In the chapter devoted to Sweden, we examined at length the tattoo death to kings born upon the body of the founder of the House of Bernadotte. There, the tattoo was the emblem of a revolutionary past that the founder of the dynasty strove to conceal. Here, the tattoos are the emblem of a criminal present that the royal family is striving to hush up. A person covered in tattoos, accused of serial rape, consuming cocaine, and moving in the circles of bikers and mafiosi. This person dwells beneath the roof of the Norwegian royal residence. His mother will become queen. His stepfather will become king. His photographs stand upon the mantelpiece in the palace. This is no mere moral decay. This is the total, absolute, irreversible degradation of an institution. A monarchy that suffers the presence of a serial rapist at its very core has no right to exist. A monarchy that seeks to disavow him by juridical sleight of hand, he is not a member of the family, yet continues to afford him shelter and protection, is no monarchy. It is a criminal syndicate, sheltering itself behind a crown. 3.6. Juridical conclusion. An elective office, not a hereditary monarchy. Let us draw the threads together. Let us apply to the Norwegian monarchy the criteria of classical legitimacy. Criterion status elucidation. Blood-absent Norway has had no native dynasty since 1380. The Glucksbergs are a Germano-Danish line, imported in 1905. No connection whatever to the ancient Norwegian conungar. Indigenat, native origin. Grossly violated Haakon VII was a Dane, born in Denmark. His son Olav V was born in England. Harold V alone was born in Norway, yet his blood remains Danish. The dynasty has struck no roots in Norwegian soil. Dynastic continuity annihilated 500 years beneath the Danish and Swedish crowns. In 1905, the monarchy was created afresh, from nothing, by a referendum and a parliamentary vote. This is no restoration, but a newly minted fabrication. Absence of morganatic marriages systematically violated. Queen Sonja is a commoner, the daughter of a merchant. Crown Princess Mette-Marit is a former waitress with a narcotic past and a child born out of wedlock. Both unions are morganatic. The monarch is not the servant of parliament. Flagrantly violated. Haakon VII accepted the throne only after a referendum and a vote of the Storting. The Constitution determines everything, including the order of succession. The monarch subsists exclusively at the pleasure of the people and the parliament. Moral authority annihilated. Princess Martha Louise. Marriage to a shaman. Commercial gin. Crown Princess Mette-Marit. Public penance for having frequented narcotic dens. The Norwegian monarchy is no monarchy in the classical sense. It is an elective office, disguised as a hereditary institution. The King of Norway is no sovereign. He is a hired functionary, whose contract was signed in 1905 and may be rescinded at any moment, should the Norwegian people, in a further referendum, conclude that a republic is cheaper and more decent. Haakon VII, the first king of modern Norway, himself placed his legitimacy and dependence upon a popular ballot. He acknowledged that his right to the throne was not inborn, but acquired. His descendants have inherited, not a crown, but a post. And that post is paid for out of the taxes of the Norwegian citizenry, who possess every right to inquire. Wherefore, do we maintain a family in which princesses trade in gin and marry shamans? The Norwegian monarchy is the youngest, the most artificial, the most juridically vulnerable in Europe. It has no foundation whatever in classical dynastic law. It subsists exclusively because, in 1905, 259,000 Norwegians voted aye. And should as many vote nay, on the morrow, it will vanish like the morning mist over the Oslofjord. And when this comes to pass, and it is inevitable, given the moral degradation of the institution, no one will be able to say that an ancient dynasty has fallen. An elective office will have fallen. An imported king, engaged by contract, will have served out his term. And the Norwegians, weary of footing the bill for this senseless spectacle, will simply decline to renew the agreement. 3.9. The first swallow. how the Norwegian parliament has already attempted to abolish the monarchy. In February of 2026, an event occurred that the Norwegian monarchists would prefer to hush up, and that Republicans the world over will remember as a turning point. The Storting, the Parliament of Norway, for the first time in modern history, brought forward for debate a proposal to abolish the monarchy and to make the transition to a republic. Yet only those who fail to grasp the dynamics of historical processes can interpret this vote as a victory for monarchy. In 1789, the Estates General of France did not vote to overthrow the monarchy either. They assembled to debate taxation. In 1917, the State Duma of Russia did not adopt a statute of abdication for Nicholas II. It was wrung from him by the force of circumstances. In 1946, the Italians, by a slender majority in a referendum, chose a republic, and the House of Savoy, which had governed for centuries, went into exile. History teaches one lesson. Monarchies do not fall at the moment when 2/3 of a parliament votes for their abolition. They fall when a crisis, economic, military, moral, attains the boiling point, and the people cease to perceive any meaning in the crown. The debates in the Storting in February of 2026 are no defeat for the Republicans. They are a test of strength. The first swallow, a signal that the ice has cracked. And when the next crisis strikes Norway, and strike it will, given the closure of the Strait of Hormuz, the geopolitical fragmentation, and the fragility of a sovereign wealth fund of $2.2 trillion invested in American technology assets, the question of the monarchy will return to the order of the day. Yet not as the initiative of a single party, but as the demand of the street. And then the 2/3 will be found. For, as history demonstrates, in the hour of truth, constitutional barriers crumble more swiftly than royal palaces. Norway shall be the first. The others shall follow. The domino has already been tipped. 3.8. The dismantling of the Glucksbergs from the Norwegian throne, a judicial strategy for the citizen of Norway. The chapter has demonstrated the case. The Norwegian monarchy is the youngest, the most artificial, and the most juridically vulnerable in Europe. Norway has possessed no native dynasty since 1380. King Haakon VII was an imported Danish prince, who himself placed his legitimacy and dependence upon a referendum. Queen Sonja is the daughter of a clothing merchant, a commoner, who contracted a morganatic marriage with the heir to the throne. Crown Princess Mette-Marit is a former waitress with a narcotic past, who for years maintained an intimate correspondence with the convicted pedophile Jeffrey Epstein. Her son by her first marriage, dwelling in a royal residence, stands indicted for serial rape and sits in the dock. Princess Martha Louise has married a shaman and convicted felon and traffics in gin bearing her monogram. In February of 2026, the Storting already considered a proposal to abolish the monarchy. The initiative did not muster the required 2/3 majority, yet the bare fact of its introduction signifies this. The taboo has been lifted. The question of the legitimacy of the crown is no longer a forbidden subject. Now the question, what is the citizen of Norway to do with this knowledge? The answer is the same as for the Dutch, the Belgians, the British, and the Danes. Bring suit in a court of law. Transform the moral decay into a juridical document. Compel the judicial system to answer the question it dreads. By what right do these persons occupy the throne? Why Norway is the most vulnerable target? Of all the European monarchies, the Norwegian possesses the slenderest reserve of legitimacy. The British crown rests upon 300 years of inertia and a global brand. The Dutch upon 2 centuries of constitutional tradition. The Danish upon the myth of the oldest dynasty in Europe. The Belgian upon the fear of the country's dissolution should the crown be abolished. The Norwegian monarchy possesses not a single one of these resources. It is young. It is artificial. It was created in 1905, not as the restoration of an ancient throne, but as the hiring of a Danish prince to fill a vacant post. It rests upon no centuries-old tradition. It rests upon a referendum in which fewer than 300,000 persons took part. It does not bind together a multinational state, as in Belgium or Spain. Norway is mono-ethnic and could be a republic without the slightest injury to her territorial integrity. Moreover, it is precisely in Norway that the moral decay of the dynasty has plumbed depths that have no parallel in modern Europe. The connection of the future queen to Jeffrey Epstein is no idle gossip, no conspiracy theory. It is a documented fact, confirmed by the published files of the United States Department of Justice. The trial of the Crown Princess's son upon charges of serial rape is no rumor. It is a criminal proceeding underway at this very hour. The marriage of a princess to a shaman and convicted felon is no private affair. It is a public demonstration that the royal family has lost all notion of the standards befitting its station. The Norwegian monarchy is no institution. It is a rehabilitation center for morally degraded individuals, financed by the taxpayer. In which court to bring suit? The Oslo District Court, Oslo Tingrett. The court of first instance for civil matters. Suit is brought against the Norwegian state, represented by its head, King Harald V. The subject of the action, a declaration of the absence of any lawful foundation for the occupation of the throne by the House of Glucksburg. Norwegian civil procedure permits actions for the establishment of juridical facts where the plaintiff possesses a lawful interest in such a determination. The Borgarting Court of Appeal, Borgarting Lagmannsrett. Upon the inevitable refusal at first instance, an appeal. The Supreme Court of Norway, Norgeshoisteret. The highest judicial instance. The final redoubt within the Norwegian jurisdiction. The European Court of Human Rights, ECTHR. Norway is a member of the Council of Europe and a signatory to the European Convention on Human Rights. Should the Norwegian courts decline to hear the substance of the action, the citizen may have recourse to Strasbourg with a complaint of a violation of Article 6, the right to a fair trial, and Article 13, the right to an effective remedy. Norwegian courts, by refusing to examine the question of the monarch's legitimacy, deny the citizen access to justice upon this question, and this constitutes a direct breach of the convention. Who may be a plaintiff? The Norwegian taxpayer. Every Norwegian surrenders a portion of his income to the budget from which the royal household is financed. The king's civil list amounts to tens of millions of kroner annually. If the dynasty is illegitimate, these disbursements are made in favor of usurpers. This constitutes a direct financial injury. A victim of the crimes of Marius Borg Høiby. Should even a single one of the women who have been recognized as injured parties in the criminal case bring a civil action against the state, arguing that the state sheltered and protected a man dwelling beneath the roof of a royal residence, a unique legal collision would be created. The court would be compelled to answer the question, wherefore does the state afford refuge and protection to a serial rapist, and how is this connected to an institution that presents itself as the moral compass of the nation? A Norwegian Republican organization. Political parties and public bodies that advocate a Republican form of government may appear as plaintiffs. Their statutory objects coincide directly with the subject matter of the action. Moreover, the Red Party, which has already initiated the debates in the Storting, could serve as the ideal plaintiff. A descendant of the ancient Norwegian dynasty. The last Norwegian king to govern from Oslo before the union with Denmark was Håkon VI, who died in 1380. His descendants in the female line are scattered among the European dynasties, and in theory it is possible to find a person who possesses a stronger right to the Norwegian throne by blood than do the Glucksburgs. This path is, however, a difficult one and demands serious genealogical research. Upon what to build the action, the 6 pillars. The Norwegian case possesses 6 pillars in place of 5, one more than the other countries, owing to a unique point touching Epstein. The first pillar. The monarchy was created by referendum. Håkon VII became king, not by right of blood, but because, in November of 1905, 259,563 Norwegians voted for a monarchy. He himself demanded this referendum, declaring that he would not accept the throne without the people's approval. In classical dynastic law, this is a catastrophe. A monarch cannot place his legitimacy in dependence upon a ballot. If the crown was received from the people, then the people may also take it away. This is no monarchy. It is an elective office with a hereditary facade. The second pillar, the absence of indigenat. Håkon VII was a Danish prince, born at Charlottenlund near Copenhagen. His son Olav V was born in England, at Sandringham. Harald V alone became the first Norwegian monarch in more than 500 years to be born in Norway, yet his blood remains Danish. The Glucksburgs are a Germano-Danish line that has struck no roots in Norwegian soil. The principle of indigenat demands that a monarch be flesh of that land. The Glucksburgs are aliens. The third pillar, morganatic marriages. Queen Sonja is the daughter of a merchant, a commoner, possessing no royal blood. Crown Princess Mette-Marit is a former waitress with a narcotic past and a child born out of wedlock. Both unions are morganatic. The issue of these unions, Crown Prince Håkon, Princess Ingrid Alexandra, possess no right to the throne under classical dynastic law. The fourth pillar, the Epstein connection. Crown Princess Meta Marit for years maintained an intimate correspondence with Jeffrey Epstein, a convicted sex offender. The correspondence was conducted from 2011 to 2014 after his conviction. She styled him sweetheart and soft-hearted, flirted with him, accepted his hospitality at his residence in Palm Beach, and discussed with him wallpaper bearing naked women for the room of her 15-year-old son. This is no poor judgment. It is the total moral bankruptcy of a future queen. In classical dynastic law, the connection of a member of the royal family with a criminal of this magnitude constitutes a ground for the forfeiture of the right to the throne. The fifth pillar, the criminal past and present of the royal family. Meta Marit has publicly repented of having frequented narcotic dens. Princess Martha Louise has married Durek Verret, a charlatan shaman with a criminal record, who served a prison term for arson. Marius Borg-Høiby, the son of the crown princess, dwelling in the royal residence of Skogum, stands indicted for serial rape, the possession of cocaine, and ties to organized crime. A royal family in whose innermost circle such a concentration of criminality is found cannot lay claim to any moral authority. The sixth pillar, the political moment. The Storting has already examined the question of abolishing the monarchy. The subject of the Glucksberg's legitimacy is no longer a forbidden topic. A judicial action brought at this hour will not be dismissed as the marginal prank of an eccentric. It will be received as a part of a broader political process. The court will be compelled to take it in earnest, because, beyond the walls of the courthouse, this same question is already being put by the deputies of the parliament. The Epstein connection as the central element of the action. The pillar connected with Epstein merits particular attention. This is no mere moral argument. It is a juridical fact, susceptible of documentary proof. The files released by the United States Department of Justice contain more than 1,000 mentions of Meta Marit. The correspondence was conducted from 2011 to 2014, that is to say, after Epstein had been convicted and registered as a sex offender. Meta Marit knew of his crimes. In one of her messages she wrote, "I Googled you. It didn't look too good, smiley face." The smiley face at the close of this message is no mere inept punctuation. It is the token of a moral stupefaction. The content of the letters is playful, flirtatious, personal. She called him such a sweetheart and wrote, "You tickle my brain." She sought his advice upon the question of what wallpaper to hang in her son's room. The selfsame son who now sits in the dock charged with serial rape. The plaintiff may argue, a woman who maintained intimate relations with a convicted pedophile and styled him soft-hearted cannot be a queen. Her moral bankruptcy is established by documentary evidence. Her right to the throne has been annulled by her own acts. A Norwegian court will, in all likelihood, decline to hear the substance of the action. The arguments will be the standard ones, a political question, a one of standing, the expiry of limitation periods. The Norwegian constitution is one of the most rigid in Europe, and a court will not alter it by a solitary decision. Moreover, a political process is already underway in Norway. The Storting has already debated the abolition of the monarchy. The Red Party's initiative did not carry, but it has set off a chain reaction. A judicial action brought at this moment will become fuel for the next round of debates. Even if the court refuses, the bare fact of the lodging of the action will be employed by the Republican deputies as an argument. Look, even the courts cannot ignore this question now. A practical plan. Step 1. Find a Norwegian jurist specializing in constitutional law and human rights. He must understand that the object of the proceeding is not an instantaneous victory, but the creation of a public precedent and the catalysis of a political process. Step 2. Prepare a statement of claim grounded upon the 6 pillars. Lay particular stress upon the documented facts, the referendum of 1905, the correspondence of Meta Marit with Epstein, the criminal case of Marius Borg-Høiby. Append copies of the published Epstein files. Append extracts from the criminal case. Step 3. Lodge the action in the Oslo District Court. Join as plaintiffs, a Norwegian taxpayer, a Republican organization, a victim of the crimes of Marius, should she consent. Step 4. After the anticipated refusal, appeal to the Borgarting Court of Appeal, and thereafter to the Supreme Court of Norway. Step 5. After the exhaustion of domestic remedies, apply to the European Court of Human Rights with a complaint of a violation of Article 6 and Article 13 of the Convention. Step 6. Coordinate the judicial proceeding with the political one. Transmit all judicial documents to the Republican deputies for employment in the debates in the Storting. Every judicial decision, whether it be a refusal or the granting of the application, must become a news event. Step 7. Document every stage of the proceeding. Issue press releases. Grant interviews. Employ each judicial hearing as a platform for bringing the arguments before the Norwegian public. Who shall cast the first stone? The Norwegian monarchy is the most brittle in Europe. It has no roots. It has no history. It has no charisma. It has only inertia and propaganda. Yet inertia dissipates when the son of the future queen sits in the dock upon charges of rape. Propaganda loses its force when the future queen herself styles a convicted pedophile a soft-hearted sweetheart. Moral authority evaporates when a princess traffics in gin and her shaman husband peddles amulets that purport to heal cancer. Norway shall be the first, not because the Norwegians are the most enlightened or the most Republican-minded, but because the Norwegian monarchy is the weakest. Its frame is splitting at every joint. One well-prepared judicial action will suffice to render those fissures visible to all. And when this comes to pass, the others shall follow Norway. Denmark, where the queen retired like a state pensioner. Belgium, where the genocidal king still stands in bronze upon the public squares. The Netherlands, where Parliament retroactively legitimated the flight of 1940. Britain, where a German dynasty has been pretending to be English for 300 years. The domino has already been tipped. The first swallow has already taken wing. It remains only to lodge the action.